Morning and welcome to an oral argument session for the 5th District Court of Appeal. My name is Rand Wallace and I'll be presiding today. On the panel today we have from Marion County, Judge Brian Lambert, and from Seminole County, Judge Eric Eisnagel. And we have one case on the docket here at 9 o'clock. I'm going to assume that the state would like 5 minutes for rebuttal unless you tell me otherwise, Ms. Parrish.
Sure, that's fine.
And then just wanted to make sure everybody silences whatever devices they have that may go off during the oral argument. But other than that, we have two very experienced lawyers here and we look forward to your argument. And Ms. Parrish, you can begin when you're ready.
Okay, thank you. May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. It's the state's position that the trial court erred in granting the 3 motions to suppress. In doing so, the court found that for the first motion to suppress, the court specifically looked at paragraph 7 of the affidavit and found that the facts in there, alleged in there, were not facts, that they were conclusions. And as such, there was no probable cause to issue the warrant. Then the judge, to be consistent, as she said, with the other 2, went ahead and granted those as well, finding there was no probable cause. It's the state's position, if you read the 4 corners of those affidavits, that they do present sufficient facts, substantial facts, that the court could find probable cause to issue the search warrants. And also, even if the affidavits were not sufficient, if they were lacking in any respect, the trial judge should have applied the good faith exception. The exclusionary rule isn't a gotcha rule. The judge could have, there was nothing to show that the officer would have known when the trial judge issued the warrant that there wasn't a sufficient basis. The trooper did what the trooper needed to do. He applied for the warrants, he did his affidavits, he set forth the facts, and the judge issued the warrants. And the trooper served those warrants in accord with the ruling of the trial judge.
Ms. Parrish, it appears that the information relied upon as support for the warrants would be basically a compounding of information that was gathered. It would be the fellow officer rule. Is that basically what we're talking about?
As far as the officer that was at the emergency room, what she observed?
Just overall,
is that,
as far as the investigation and the information that went into compiling the warrants, we're talking about just kind of the tried and true fellow officer rule. Is that correct?
Yes, that's correct. That's correct. If there are no other questions, I would ask that you reverse and
Counsel,
send this back.
If we could just narrow the issues here, did you argue the good faith exception below?
The prosecutor below did not argue the good faith exception. However, I would submit, whether it was argued or not, it's a determination that the trial judge should have made in ruling on this. That the exclusionary rule isn't a gotcha rule. The trooper in this case, I don't believe the affidavits are lacking. If they are, he certainly didn't know that they were. And when the judge issued the search warrants, the 3 different magistrates issued the search warrants, he relied on that.
Counsel, I certainly, I see the argument that you're making, and it seems to have at least some weight to it. But if the state wants to assert an exception, why does that argument not need to be preserved?
I think in some cases it does need to be preserved, but I think for the exclusionary rule for this, I don't believe it needs to be. I think this is something that the judge, as a practical matter, should have done. To me, it's sort of analogous to the, for speedy trial, the recapture window. You don't get to just ignore the recapture window. And when that is ignored, it goes back, you get that recapture. I think the exclusionary rule, it's the same, good faith exception, it's the same thing. It should be, whether it's argued or not, it's something that should be part of the determination made by the trial judge in ruling on the motion to suppress.
So I mean, I guess I'm losing you a little bit. Are you suggesting that it's fundamental error to not consider it?
I thought about that, if it's fundamental error. I guess in some respects.
Doesn't it need to be fundamental error if we're going to take it up, given that it wasn't preserved?
No, I don't think it does need to be fundamental error. I think but it certainly could be considered fundamental error. It's part of the whole determination. In this case, there was no deference given to the magistrate's findings.
I don't know. I mean, it's an exception, right? It's an exception to the rule. So, is the trial court automatically required to consider every potential exception anytime the issue, the core issue comes before it?
Well, I can't talk about every issue that could possibly come up, but for the exclusionary rule, I would say yes. It's something that should be considered, whether it's brought up or not. If they're going to throw out.
Why should that be on the trial judge instead of the state to raise? Why should the trial judge raise that instead of, shouldn't the state raise it?
Well, they should raise it, but I don't think it's not detrimental in this case. Considering that the trial judge conducted a de novo review, the trial judge should have thought about the good faith exception.
Don't we need some factual findings to apply the good faith exception?
Pardon me?
Do we need any factual findings to apply the good faith exception?
I don't believe so. The rulings in this, the affidavits in this case, there is no evidence of any bad conduct on the trooper's part, the judge's part. The affidavits themselves were not entirely.
Did the trial judge make any findings regarding the good faith or the bad faith of the officers?
No finding at all. Just found that they were conclusions.
But in your view, we can make that finding?
Yes. Based on the affidavits in this case, yes. And the lack of evidence presented at the hearing.
Why would there be evidence of good or bad faith when that issue wasn't raised by the state?
Well, Mr. Hart, they argued that the troopers acts, that the affidavit was done in bad faith, but they didn't present any evidence of that. They didn't present any evidence that anything in the affidavit was false. It was his burden. None of that was presented.
Do you agree that hearsay is permissible to be relied on in the preparation of the affidavit in support of a search warrant?
Yes, sir.
Standard. So basically we have here is the passenger of the defendant saying to somebody that, hey, Mr. Hart was impaired and drank too much before he got in this accident. I mean, that's in the affidavit, right?
Yes, sir.
Okay.
That is in the affidavit.
So you have that, and you have a fatal accident, and then we have a second trooper, not the affiant, but a second trooper who apparently observes Mr. Hart at the hospital within a matter of a few hours after this accident. And although, if I'm gleaning from the appellee's brief, the fact there's no mention of odor of alcohol apparently is one of the significant factors in their view. But there's other indicia that can suggest somebody was under the influence of alcohol. From
Correct.
Trooper Hawkins, I believe. Now,
Correct.
That kind of ties back to what Judge Wallace was indicating in the fellow officer rule. Even if the affiant didn't see that, these people, Trooper Hawkins, and in fact, there was I guess an Orange County deputy was at the scene as well, who observed the defendant actually in the driver's seat. the affiant can rely on those other investigating officers' information when the trooper prepares the affidavit here that was presented to the various magistrates for the search warrant? I mean, that's permissible, right?
Correct. That is correct.
So then we have a fact. So then what was presented to the magistrates regarding the warrants was the passenger of the defendant said the defendant had been drinking too much and was impaired. And there was indicia of the defendant being under the influence at as indicated by the trooper at the hospital's observations. And so that's presented to the magistrates, who then just have to make a common sense approach whether there's going to be evidence that a crime was committed to authorize the search warrant. I mean, isn't that what this case is?
Yes, sir. That's exactly what this case is.
That's what those magistrates did. And then the trial judge here was required to give great deference to that. And, you know, I actually agree with Judge Eisnog. I think you have to preserve the issue of the good faith exception. But to me, this case doesn't need that, frankly. It seems like there was factual statements prepared and given that I don't know of any law that says every investigating officer has to sign an affidavit in support of search warrants. I certainly, as a trial judge, never got 9 affidavits from the 9 investigating officers before I had to sign a search warrant. And that seems to be that the argument here is that the affiant didn't explain how he gathered the information. Therefore, it's bare bones and lacking, which I'm at a loss as to why that is.
I would agree with that, Your Honor.
Okay.
If there are no more questions, I would rely on my brief and ask that you reverse this case. Thank you.
All right, Mr. Hyman, you may proceed.
May it please the court. The affidavits in this case are a legal model of how not to write an affidavit for a search warrant. The officer self-proclaims in the affidavit that he has 4 years experience as a homicide investigator and has been involved in over 50 traffic homicide cases. But yet the search warrant that was written in this case could not be used in a class to teach a police officer how to write a search warrant based upon
Counsel, why don't you just tell us what exactly was deficient instead of sort of these sort of conclusory labels? What exactly was deficient about the affidavit?
The entire affidavit is conclusory for the most part.
How's it conclusory when they say, okay, the passenger says this guy drank too much and was impaired? I mean, that's a statement that an officer can rely on. How's that conclusory? That's the passenger's observation of your client immediately prior to the accident. Does he have to say, well, I make that conclusion because I have some degree in pharmaceutical knowledge or something like that?
No, not at all. But what he has to say is that he spoke to officer so-and-so and officer so-and-so told me this is what they saw. At this point in time, we have no idea where this information came from because the affidavit doesn't say that anybody spoke to anyone. In order to have a fellow officer rule, my understanding, and it's not in the brief because I didn't know this issue of the fellow officer was going to come up, but there has to be a communication between officers for the fellow officer rule to apply. You just can't assume that some other officer knows something and then therefore I know that.
So are you suggesting then the affiant in this case really got no information from Trooper Hawkins at the hospital and he just made this up and wrote it in his affidavit?
It may have been 3 or 4 people removed. We just don't know. We don't know that he directly spoke to Trooper Hawkins. He may have been going through 3 other people, and the same with a lot of the other information in this particular affidavit. There usually, for any conclusion that even a witness gives in court, there has to be a predicate established for the conclusion.
Well, that's in court, right? But I mean, hearsay is.
I agree, hearsay is admissible, but usually when it comes to hearsay, based on the totality of the circumstances and what used to be Aguilar versus Spinelli, but is no longer under Gates applicable, but you still have to be able to judge the credibility of the information or the person who's providing the information, and whether they were even in a position to even see what they say they're telling you.
Well, obviously, the passenger was in the position to see it, and so the passenger says this, and so I guess maybe I'm asking it in the wrong manner. So if the trooper said in his affidavit, the affiant said, I spoke to passenger and he told me this guy, Mr. Hart, had been drinking a lot and was impaired in his view up until prior to the accident, and that was in the affidavit. And then that would basically, if I'm getting it, would certainly gut significantly your argument here, wouldn't it?
Yeah, if there was a predicate. These are not just technicalities with regards to affidavits for search warrant, because there's a slippery slope that can arise by affirming these particular affidavits. Police officers in the future could decide, you know what, I'm never going to put the source of my information in for these affidavits, because if I leave the source out, no judge can weigh the credibility of that source.
But the source is in here. The source. I mean, if the trooper simply said the defendant or Mr. Hart was impaired and had too much to drink, and there was no nexus as to where that information came from, then your argument to me would have more weight. But here, it's the guy sitting next to him in the car says this, and it goes in the affidavit. And you're saying because the troopers doesn't say, I heard him say that, or this fella told the deputy who then told me, the trooper, that becomes problematic because we're slippery sloping. Is that your position?
It is to some degree, yes, because we don't even know if this individual, nobody says they actually heard this individual say that. That individual may never have said that, for all we know. There's no way of knowing from the four corners of this affidavit whether that was ever actually said. It's just put in there. The entire
Counsel, what's the alternative? I mean, what's the common sense alternative to the individual said it? The only common sense alternative I can think of is that the officer baldly lied and made it all up. What's the in between?
The in between and the problem here is that there's no way for a judge to question where this information came from, or whether that person was even in a position to know what they say they're given credit for having said in the affidavit. There's no predicate as to how, why, where, who, when it occurred. And from a defendant's standpoint, or even from a judge's standpoint, there's no way to go back and even determine where this information came from.
Okay, but the affidavit says, I'm the trooper, I'm on the scene, this fella is a passenger, and this fella said, the passenger says, impaired, drinking too much before the accident. I mean, so we have two people who are on the scene, and that's what comes through in the affidavit. And as Judge Eisenhower, it's a common sense approach that magistrates have to take when they get that. Like saying, I mean, I guess I'm trying to figure, I would have to say, well, okay, I don't believe that. I want an affidavit from the actual person himself, who the passenger who said that. And no, there's no case law that requires that.
Well, the problem is, in this case, there's even a Mr. Gay that's mentioned.
You know that's a typo. You know that's a typo. That's disingenuous. You know they weren't talking about a Mr. They just pulled out a name. I mean, because they corrected in the later affidavit.
Well, that's my point. There was a lot of cut and pasting going on between the different affidavits. If you read them together,
Counsel, let me ask you this. In the first affidavit, paragraph 5, tell me what's wrong with this sentence, if anything. Sergeant Roberts identified Kevin Tyler Hart by his Florida driver's license as Kevin Tyler Hart. What's deficient about that? I'm just curious. What's deficient about that sentence, if anything?
I don't see anything deficient in that particular.
Does that sentence establish that Sergeant Roberts was on the scene and identified Kevin Tyler Hart by looking at his driver's license?
Absolutely. And the identification was not the issue of who the driver was.
No. I know. I'm just asking you, does that, so let me ask you this. Under your argument, shouldn't that sentence have said, I spoke to Sergeant Roberts, who told me that he personally identified Kevin Tyler Hart by his Florida driver's license?
I think if you take a common sense approach to that particular sentence,
Right.
yes, I agree that one would pass muster.
Counsel, shouldn't we take a common sense approach to all of the sentences?
Well, some of the other sentences, no. I
Well,
mean,
show us a sentence.
I think you should take a common sense approach, but I don't think a common sense approach
Right.
would establish where that information came
Show us
from.
a specific sentence. Let's talk about a specific sentence that you say is deficient.
Well, actually, paragraph 7, which actually came up in the hearing, which was the one that the statements provided by Mr. Basio of Kevin Tyler Hart being impaired and drinking too much driving the vehicle. That there's no information in this affidavit as to who received that information from Mr. Basio, if he ever said it, how it was said, where Mr. Basio was, whether Mr. Basio had been drinking himself, whether there's just nothing in here to give any predicate as to where that came from.
So your beef with that then is the statements provided by Mr. Basio. If instead the affidavit had stated the statements provided to me by Mr. Basio of Kevin Tyler Hart being impaired and drinking too much.
If somebody could swear to that, yes.
All right, so you're assuming that the statement was not made by Mr. Basio to the affiant because it doesn't say to me, or it doesn't say to Deputy Rogers, who then told me, or something like that.
I don't know, and I don't think anybody could know from that particular statement whether it came from him or not, or how it came, or whether it was quadruple hearsay, quintuple hearsay. There's just no way of knowing what the source.
It's a common sense approach. So the trooper's on the scene right away, the deputy's on the scene right away, the passenger's still there. This first search warrant is obtained within 3 or 4 hours. So somehow we have to, from a common sense approach, that he must have told, Mr. Basio must have told one of these officers there. He didn't just tell his girlfriend on the phone, who then called her mother, who then called the deputy or something like that. And they relied on that and they went and got a search warrant. I'm at a loss as to why this is so problematic.
Well,
having received many warrants in the middle of the night as a duty judge when I was a trial judge.
My position is and my client's position is that, these are not just technical niceties. These are requirements. There's a burden of proof to get a search warrant before you can invade somebody's right to privacy. And that burden of proof, the state has that burden, and they're held to a standard that they have to meet in compliance with what are accepted principles of writing an affidavit for a search warrant. The case law,
a subsequent trial judge reviewing an affidavit like this, what's the standard of that the subsequent trial judge is supposed to use?
Whether there was a substantial basis for the issuance of the search warrant.
But they have to give great deference to the magistrate's determination.
They do,
because the magistrate's talking to the affiant about what's happened, as we all do when we get these things. They talk to him and say, okay, tell me about this. And so the magistrate hears this, reads the affidavit, reads a search warrant, and says, okay, I think there's sufficient probable cause here. Now, Judge Adams has no idea what was talked about.
Well, the problem with that is that you're supposed to be confined to the 4 corners of the affidavit. You're not allowed to take extraneous information from an officer and consider that in granting or issuing the search warrant. Mm-hmm. The problem is you're supposed to look at the 4 corners of the affidavit, and if it's not in the affidavit, then the affidavit is insufficient. And this is where
Counsel, how does that change this? How does that change the standard of review for the subsequent trial judge? It is still a standard of corners. It's great deference, correct? And common sense.
Well, it's deference unless, as Illinois versus Gates said, you're relying on the conclusions of others. Then it's not so much deference.
No. What I'm asking you is the standard is great deference and common sense, correct?
Yes, I agree.
So are we to expect an officer completing an affidavit to do so as if they are entering evidence at trial?
No, I don't think we have to go that far, but I think there's certain accepted predicates over the years of case law that say that conclusions are not sufficient, that there has to be facts in the affidavit, just articulated facts to support the conclusion that's in the affidavit. Otherwise, you're getting down to a bare bones affidavit that Illinois versus Gates warned.
Well, how is the sentence in paragraph 7 a conclusion? That's a statement of fact. Your argument with that, the statement provided by Mr. Basico, your argument with that is that, well, we don't have a predicate for that. We don't have a foundation for that. That's a statement of fact, right?
I'm sorry. It's not really a statement of fact. It's actually a conclusion of Mr. Basio, which is being reiterated by the officer, and as to where he received that conclusion is not set forth in the affidavit. So therefore, there's kind of two problems, my position is, with regards to that particular statement, because it's conclusory on the part of the person giving the opinion, and then also where did that opinion come from?
Let me ask you this: how is this a conclusion? I just don't understand. I really don't understand how this part is conclusion. Kevin Tyler Hart being impaired. I mean, maybe you can call that a conclusion, and drinking too much prior to driving the vehicle. That's not a state. You call that a conclusion, not a statement of fact?
Some people would say that drinking one beer is drinking too much to get into a car. Some people would say 10 beers is too much to get into a car.
Well, does it establish that he drank alcohol and then drove? Is that a fact that it establishes?
Well, actually, it doesn't even say alcohol if we want to get specific, but we're assuming drinking means drinking alcohol.
But counsel, we're still in the common sense zone, right?
We're trying to be, but this affidavit is so lacking.
No. Tell me about this statement right here. Drinking too much prior to driving the vehicle. Using a common sense approach. Does that establish that he drank alcohol and then drove?
How would I can't agree with that for one reason, because it does say that, but whether this individual even saw what the person was drinking to know that he was.
But that's not. But my point is, you're talking about the foundation. You're essentially saying, look, there's not enough foundation here for us to know how he knew that and that. It's not a conclusion. That's a statement of fact. Your issue is you think there should have been more foundation laid, more of a predicate.
I still believe that that's a conclusion, with all due respect.
Can you please explain that to me then? How is that a conclusion? He drank too much prior to driving.
Because
how is that not a factual statement?
Drinking too much. First off, we're assuming that he was at a table or something and saw him drinking. So we don't know what the basis is.
That again goes to the foundation for the statement, not the actual.
He could have received that information from another person who told him he was drinking too much.
All right. So your issue is really just the predicate or the foundation. It's not that your issue is not that that's a conclusion versus a factual statement. Your issue is, look, we don't know how the witness knew those facts.
It's probably a credibility issue.
Basically, you're saying this witness should have said, I was with Mr. Hart for 2.5 hours. We were sitting at a bar. He had 8.5 drinks during that period of time. They were whiskeys and waters and rum and Coke and whatever. And then at such and such a time, we got in the car, and then 30 minutes later, we were in an accident. That I guess would satisfy you.
Well, that would be very good. I don't know that it has to go necessarily. I don't know that it has to necessarily go that far. But again, we don't know where the trooper got this information to put it in here, and we don't know whether that information was relayed by a third person that said somebody else saw him drink. We just don't know, and that's part of the problem. It's kind of like the.
Will you agree that the affidavit says that particular witness was the right front passenger? Correct.
And again, that
paragraph 5.
Yeah, that also is. There's no predicate how that was even determined as well. To be honest, it's kind of and I hate to date myself, but it's kind of like that fast food chain, like, where's the beef? There's no beef in these assertions. If you read this whole affidavit, it's a really just a conclusory affidavit. I mean, I've seen lots of affidavits for search warrants, probably not as many as you judges have, but usually they say, I spoke to Mr. So-and-so, Mr. So-and-so said this, or there's some source of information and how.
How about this? How about this? Deborah Hawkins observed Kevin Tyler Hart for signs of impairment while at Orlando Regional Medical Center. This is in paragraph 5. Kevin Tyler Hart had bloodshot, glassy eyes, a slurred speech, and was drooling out of the left side of his mouth, all being consistent with being under the influence. What's deficient about that?
What's deficient about that is, first off, the slurred speech is a conclusion as well.
Slurred speech is a conclusion?
Well, some people think speaking slow is slurred speech. Some people think putting words together is slurred speech. There's no basis for the conclusion. Not only
How
that,
about the bloodshot, glassy eyes? Is that a factual statement or a conclusory statement?
Bloodshot glassy eyes would be a factual statement, but bloodshot glassy eyes in ANH versus State, which is cited in the brief, is
How
not
about
a
drooling
basis.
out of the left side of his mouth? Factual or conclusory?
That's probably factual.
And we know where this came from, right? This affidavit expressly says it came from Deborah Hawkins.
Well, it says that Deborah Hawkins observed that. It doesn't say he ever spoke to Deborah Hawkins.
Right. So you want him to lay out in the affidavit as if he's entering evidence at trial.
Your Honor, I don't want him to lay anything out. What I want is what the law requires. The law requires.
Well, I'm asking you what you think that is required here. You think he needs to lay it out as if he's a lawyer at trial?
Not as a lawyer at trial, but at least showing that he actually spoke to these people before he put these things in here. Again, we don't know if it's quadruple hearsay 4 officers later, we don't even know if the officers communicated with one another. The problem is it leads everything to speculation. And at first glance, when you read this affidavit, you would say, hey, it looks, these are in facts. But then when you read that there's no sources for the facts, that they're conclusions, then that's where the problem lies with the writing of the affidavit, because they're not technical niceties, as the courts have said. These are requirements that need to be, conclusions are just not acceptable in an affidavit for a search warrant. And this whole affidavit is a conclusion there's exceptions in there, but for the most part, it's strictly conclusions.
Mr. Hyman, you're out of time.
Okay, thank you.
All right, Ms. Parrish, you've got about 9 minutes.
I don't have any further unless there are any other questions. I would just point out that the affidavit all the affidavits establish probable cause and were sufficient on their face. And I would ask that you reverse. Thank you.
Counsel, why not in the affidavit just say, hey, look, I spoke to all these officers. I mean, you could just do it in the first paragraph of the affidavit, say, look, I was on the scene and the following 5 officers were on the scene, and I spoke to all of them and got the following facts from these officers. Or, I mean, at minimum that, right? Why not do that?
I mean, they could do that, but they're in the middle of an investigation, especially for this first warrant where they were seeking the blood draw, and they needed the blood draw done quickly. Personally, when I read the affidavit, I mean, using common sense, how else is he going to find out? I don't think there's anything in here that says, 3 other deputies told him what the first deputy said, and it went through all 3 of them. I mean, my reading of it is that information was obtained from those people that he mentioned.
Let me ask you this. I mean, if it had gone through 3 deputies, is there a problem with that? Is that insufficient?
No, I don't believe there is. I don't believe
it would have
there
been
is.
insufficient if he just made it up, though, right?
Yes. If he had made it up and there was evidence of that, absolutely. There's no evidence that anything in these affidavits were made up. I have nothing further. Thank you. I ask that you reverse.
Okay, thank you for your arguments, and we are now